Picture a rainforest on a remote Indonesian island. A photographer has spent days following a troop of wild-crested macaques, black-furred, amber-eyed, endlessly curious. He sets his camera on a tripod, steps back, and one of the monkeys does something no one planned. It walks up to the lens, sees its own reflection, and starts pressing the shutter. Most of the shots are blurred chaos. But one is perfect. A wild animal, staring straight into the camera, mouth open in what looks exactly like a grin. It is, by any measure, a stunning photograph. And it would go on to trigger one of the strangest legal battles of the century. Because that single image forced courts, lawyers, and a government office to answer a question that sounds like a joke until you really try to answer it. When a monkey takes the photo, who owns it? Stay with me, because the answer isn't really about a monkey at all. It's about you, and about every image being made by a machine right now. Here's why this isn't simple. Copyright, the law that says you own what you create, exists to protect human creativity. When you write a song, snap a photo, or paint a picture, the law instantly hands you ownership the moment you make it. You don't have to register it. You don't have to ask. Creation equals ownership. But copyright has always rested on one silent assumption, so obvious that for centuries nobody bothered to write it down clearly, that a person did the creating. The photographer's argument was straightforward. Yes, the monkey pushed the button, but I set up the shot. I traveled to the jungle. I positioned the camera, chose the settings, spent my own money and days of my life to make that moment possible. The monkey was basically my tool, he said, like a self-timer with fur. And remember what was at stake for him. This wasn't a hobby snapshot. He had sunk thousands into the trip, slept rough in the forest, and earned the trust of a skittish wild troop over days. By any normal standard, that effort is exactly the kind of thing copyright exists to reward. It is not a crazy argument. We give photographers credit for capturing lightning or a wild animal mid-leap all the time, even though they didn't control the exact instant. So is a monkey pressing a shutter really so different? Hold that thought, because someone with a very different answer was about to get involved, and they weren't on the photographer's side. They were on the monkey's. Before the courtroom drama, the image did what striking images do: it went viral. It spread across websites, news articles, and social feeds around the planet. And then it landed somewhere that turned a viral hit into a legal nightmare. A massive online encyclopedia, one of the most visited websites on Earth, added the photo to its library of free images. Their reasoning was as bold as it was simple. A copyright, they argued, can only belong to a human author. No human took this picture. The animal did. Therefore no human owns it. And a work with no human author isn't protected at all, it belongs to everyone. It's in the public domain. Free for anyone to use, forever. For the photographer, this was a catastrophe. The single most valuable image of his career, the one that could pay back years of work, had just been declared free for the entire world to copy. He demanded they take it down. They refused. He argued he was losing real income. They held their ground on principle. And quietly, in the background, the most powerful authority on the question was about to weigh in, not a court, but the government office that defines what copyright even is. In the middle of the storm, the United States Copyright Office did something rare. It updated its official rulebook to address the controversy almost directly. The new language was blunt. The office will register a creative work only if it was made by a human being. And then, to leave no doubt, it gave examples of what it would refuse. A mural painted by an elephant. A song attributed to a divine spirit. And, almost certainly with this exact case in mind, a photograph taken by a monkey. Read that again. A government office formally wrote down that a monkey's photograph cannot be copyrighted. Not because the photo is bad. It's a great photo. But because copyright is a deal society makes with human creators to reward human effort, and an animal isn't a party to that deal. This should have been the end of it. The principle was clear, the rulebook was updated, the photographer had lost his ownership claim, but at least the chaos was over. Except it wasn't over. Because a major animal rights organization looked at this whole mess and saw something nobody else had, an opportunity to argue the exact opposite. Not that nobody owned the photo, but that the monkey did. In 2015, the organization filed a lawsuit in a United States federal court. The plaintiff, the one supposedly wronged, the one suing, was the monkey. They even gave him a name and claimed he was the rightful author and owner of the selfie, and that the photographer had infringed the monkey's copyright by publishing it in a book. Their goal was bigger than one photo. If they could get a court to say an animal could own property, it would be a historic step for animal rights, a crack in the legal wall that says only humans can hold legal rights at all. The photographer, already nearly broke from the fight, now faced a federal lawsuit brought in the name of a monkey who, of course, had no idea any of this was happening. Think about the corner he was in. He had already drained his savings defending a photo the internet had declared free for everyone. Now he had to hire lawyers all over again to defend himself against a macaque. Every month the case dragged on, his money shrank, while the single image meant to secure his future earned him almost nothing. The case was as serious as it was surreal. Lawyers in suits stood before a judge and argued, with complete sincerity, about a macaque's intellectual property rights. Newspapers had a field day. But underneath the comedy was a genuinely hard legal question, and the court had to give a real answer. Could an animal sue at all? The answer, in the end, was no, and the reasoning is the whole point of this story. To bring a lawsuit, you need something lawyers call standing. Standing means the law actually recognizes you as someone who can walk into court and make a claim. And the courts ruled that animals do not have standing to sue for copyright infringement. The law that created copyright was written for people. Nothing in it gives an animal the right to file a case or hold a copyright. An appeals court agreed. The monkey could not own the photo, and could not sue over it. So where did that leave everyone? In a strange in-between place that is the real lesson here. The monkey couldn't own it, because animals can't hold copyright. The photographer couldn't fully own it either, because in the eyes of the law he didn't create it, the animal pressed the button. The work was, in a sense, an orphan, an image that legally might belong to no one. Before the final ruling, the photographer and the organization reached a settlement. He agreed to donate a portion of any future earnings from the monkey photos, reported as 25%, to charities protecting the very macaques in that forest. A messy, human compromise to end an impossible question. But the principle the case carved into law would outlive every detail of it. And today, it matters more than ever. Here is the part that should give you chills. For most of history, the rule that creativity requires a human author was invisible, because what else could possibly create? Then a monkey pressed a shutter, and the law was forced to say the quiet rule out loud: no human, no copyright. At the time, it looked like a bizarre footnote. A funny story about a grinning macaque. But think about what creates images now. You type a few words, and a machine paints a photograph that never existed. You ask software for a song, a poem, a painting, and seconds later, there it is. So who owns that? The exact same principle from the monkey case is now the front line of the biggest creative rights fight of our era. Copyright offices and courts have leaned on that same logic: a work generated purely by a machine, with no meaningful human authorship, may not be protectable at all. We are watching it happen in real time. An artist generates a striking image from a single sentence, tries to register it, and is told the parts the machine invented cannot be owned. A studio films a scene, then asks who holds the rights when the software did the heavy lifting. Every one of those fights traces straight back to the question a monkey asked first. The monkey Selfie wasn't a footnote. It was a rehearsal. A wild animal in a jungle accidentally tested the deepest assumption in creative law, that behind every work stands a human mind, years before the rest of us needed the answer. So the next time you generate an image with a single sentence and feel a flash of pride, remember the macaque, and ask yourself the question that started it all: if you didn't really make it, do you actually own it? Tell me what you think in the comments, because honestly, the courts are still arguing about it too.